A federal judge just made a decision that will follow Todd Blanche into his confirmation hearing. Monday morning, U.S. District Judge Kathleen Williams issued a 56-page order that nullified Trump's $1.776 billion settlement with the IRS and referred the acting attorney general to the New York State Bar for disciplinary proceedings. Blanche's Senate confirmation hearing begins Wednesday, and every word of Judge Williams' ruling will be waiting for him in that chamber. Judge Williams's language was direct and unsparing. She wrote that Trump v. Internal Revenue Service was an attempt to use the court to provide some legitimacy to an agreement to confer immunity to people and entities affiliated with the president and to earmark billions of dollars from American taxpayers to redress grievances not defined in the law. That's a judge saying the entire lawsuit was designed for improper purposes, and that the people who engineered it knew exactly what they were doing. Trump filed a $10 billion civil lawsuit against the IRS over the leak of his tax returns by IRS contractor Charles Littlejohn, who is now serving a 5-year prison sentence. But the lawsuit wasn't about damages. It was about creating an anti-weaponization slush fund designed to pay out taxpayer money to Trump and his allies for grievances that weren't even defined by law. Judge Williams found the critical issue. Trump was suing an entity he controlled. The lead plaintiff and the government are one, a fully realized unitary interest. There was no real case or controversy, no opposing parties with competing legal interests, just Trump and a Justice Department working for him. No adversarial process, no independent review. Just moving money around and claiming it was a legitimate court settlement. The settlement would have created the $1.776 billion fund and shielded Trump from more than $100 million in tax penalties the IRS had assessed. The IRS audit protections would have been sweeping across multiple years and financial categories. But Judge Williams barred any use of that settlement in any judicial, administrative, or regulatory proceeding. It's effectively dead. The entire foundation of the fund is gone. The entire basis for tax protections is erased. It cannot be used anywhere, by anyone, in any context. The crucial part involves who signed off on it at the Justice Department level. Todd Blanche, now acting Attorney General, and Stanley Woodward, now Associate Attorney General, both had previous representation ties to Trump and his co-defendants. These weren't casual connections. Woodward represented Walt Nauta in the Espionage Act case over classified documents at Mar-a-Lago and represented multiple witnesses in that same case. These are direct conflicts of interest that create ethical obligations. Judge Williams wrote, "While the court appreciates that attorneys successfully transition between private practice and government service, such transitions do not absolve counsel of their ethical obligations." She noted that their former clients stood to benefit from the $1.776 billion fund. She referenced the Mar-a-Lago case as a quintessential anti-weaponization claim. Then she wrote the crucial accusation. Instead of either recusing because of their previous representations or vigorously defending this lawsuit as required to do so by DOJ policies and procedures, these lawyers agreed to a settlement involving a staggering amount of money, potentially benefiting former clients. That's a direct indictment. Either Blanche and Woodward should have recused themselves because their former clients would benefit. That's the standard ethical requirement. Or they should have vigorously defended the case according to standard DOJ procedures that require aggressive litigation. Instead, they engineered a settlement giving their former clients immunity and access to a nearly $2 billion taxpayer fund. They put their former clients' interests ahead of the United States government's interests. They put settlement ahead of litigation. Judge Williams ordered copies sent to the State Bar of New York and the District of Columbia Bar. Disciplinary proceedings against both Blanche and Woodward are already underway in those bars. The judge's referral is going directly to the entity investigating whether Blanche's conduct violated ethical rules for attorneys. Woodward faces the same process with the DC Bar. Both men now have a federal judge's detailed analysis of their alleged ethical violations sitting on the record. She also referred Trump's Florida-based personal lawyer Alejandro Brito to the Florida Bar for possible discipline. What makes this moment devastating is the timing combined with the substance. Blanche has spent recent weeks on Capitol Hill lining up support for his confirmation as Attorney General. He's been working to win over GOP skeptics who might question his loyalty to Trump versus his obligations to the rule of law and the Constitution. His team has been making the case that he understands the law and will run the Justice Department according to statute. Now he faces Senate questioning after a federal judge wrote that he failed to either recuse himself or vigorously defend the United States when his former client stood to benefit from an improper settlement. The judge nullified the settlement completely and referred Blanche to the bar. This happened 2 days before his confirmation hearing. Judge Williams also applauded 35 former federal judges who filed an amicus brief asking her to examine the case. She wrote that their thorough and well-reasoned scholarship and uncompromising commitment to the rule of law are hallmarks of a vigorous, independent legal profession critical to sustaining a vigorous, independent judiciary. Those 35 former judges are watching. They're on the record about their concerns. They're monitoring his confirmation hearing. Additionally, 101 former federal and state judges filed a 73-page complaint against Blanche with the New York State Bar requesting an ethics investigation. That complaint focused on 3 areas: his role in creating the $1.776 billion compensation fund, creating IRS audit shields for the president and his family, and abusing Justice Department investigative and prosecutorial powers to target the president's perceived political enemies. That's 3 separate ethical violations being documented and investigated simultaneously. The complaint was already in motion. Now it has judicial confirmation. The Senate Judiciary Committee's questions this week have new context they didn't have before. Every senator asking Blanche about his understanding of the Attorney General's role, conflicts of interest, separation of powers, and the Justice Department's independence can now point directly to Judge Williams' words. A federal judge has already found that Blanche failed to recuse himself when his former clients would benefit. A federal judge has already nullified the entire settlement. A federal judge has already referred him to the bar for investigation. Those are facts now. They're in the record. Judge Williams addressed something fundamental about the separation of powers. She wrote, "Fidelity to the rule of law can be achieved only when the DOJ is free to assess the facts and governing law of each case it reviews, without the stain of political interference." Blanche and Woodward hadn't assessed the case by law. They engineered a settlement for improper political purposes. They contaminated the Justice Department with exactly the political interference the rule of law forbids. The DOJ claimed it had the power to resolve disputes unilaterally. Judge Williams demolished that argument. Whether executive branch actors can privately agree to give themselves and their former clients blanket immunities and billions of dollars in tax monies for legally undefined grievances was never an issue advanced to this court. The question is whether the parties could do so by claiming to be adverse and engaging the legitimacy of a court proceeding. The answer is a resounding no. That answer is now part of the permanent record. It's what the Senate will use to evaluate whether Blanche should become the nation's chief law enforcement officer, responsible for ensuring the Justice Department serves the rule of law instead of political interests. Judge Williams barred any use of the settlement in any proceeding anywhere. The settlement has no legitimacy. The process was compromised by conflicts of interest. The purpose was improper. A federal judge has already written that Blanche failed in his obligations to the Justice Department and the rule of law. The ruling is 56 pages of detailed analysis explaining exactly why the settlement was improper and why Blanche should have recused himself. His confirmation hearing begins in less than 2 days. The Senate has a federal judge's analysis of his conduct. The Senate has grounds to question whether Blanche fulfilled his ethical obligations when his former client stood to gain nearly $2 billion. The Senate has a detailed ruling explaining why the entire settlement was an improper attempt to use federal courts for political purposes. Todd Blanche's confirmation hearing won't be what it would have been before Monday morning. Judge Williams changed that with 56 pages, a referral to the bar, and words that won't be forgotten by senators asking about his understanding of the rule of law, separation of powers, and the Attorney General's obligations to the United States.